I think the challenge with all the applications, even though it is blamed on council, is the time. Malanid Senior was talking earlier about us not filing responses. They are there, but they are not before the court because of when we were served. So even the responses to this application have just been served upon us. We will simply make our application on the basis of what the law provides, because we believe this court has dealt very clearly and settled matters of scrutiny. My Lord, the application is the application that is before you, the application dated the 13th of November 2017. It is supported by the affidavit of the second petitioner. We are seeking the following orders at paragraph 3 of the application, that the second respondent be compelled to give access to and supply to the court and to the parties the following documents, information, and data that is in the exclusive possession of the second respondent. We're asking for copies of minutes, all plenary deliberations of the second respondent relating to the fresh election from 1st September 2017 to 31st October 2017, both days inclusive. We're asking for copies of all internal memos prepared, issued, and/or circulated amongst the commissioners and/or the secretariat staff of the second respondent relating to the conduct of the fresh election from 1st September 2017 to 31st October 2017, both days inclusive. We're also asking for the full and unredacted KPMG audit report on the voter register, including all sections of the report that have not been made publicly available. This should include the chapter on security and penetration tests on the register of voters. My Lord, if I may address you on the basis for that particular prayer and on the basis of what this court has decided before, an application for scrutiny must be founded on the petition itself. These factors have been pleaded in the petition and form the grounds upon which the petition itself is made. My Lords, a major ground of the petition is that the first and the second respondents did not operate within the law. We have made complaints and allegations that there was internal rife within the second respondent. There was infighting within the second respondent, matters that have spilled into the public domain have not been denied and are not disputed. My Lord, as an example of the matters that are within the public domain and which the first respondent or the second respondent cannot take back and now refuse to give access to their documents are, for instance, the public resignation of Commissioner Dr. Rosalind Akombe. When that matter came out publicly, the first respondent issued a public address admitting the matters that are stated in the memo by Dr. Roslyn Akombe, and therefore opening the matter up to the public for questioning. It is therefore only right or in the interest of justice that the parties should be allowed to have a look at all the deliberations of the first and the second respondents in their decision-making, and to consider the issues that were publicly admitted, made available, or exposed to the public by the first and the second respondents. My Lords, the request that all the minutes be made available together with all the memos then takes care of the argument or the complaint by the respondents that there has been a selective production of evidence before this court. We want the full picture. On the prayer for the full and unredacted KPMG audit report on the voter register, my Lord, one of the grounds of the petition relates to the identification of voters by biometric means or alphanumeric. And these are matters that were covered in the audit report that was done by KPMG against the voter register. Those tests are relevant to the questions before this court in the petition. Prayer number 4 is that the second respondent be compelled to avail for scrutiny all the secure digital or SD cards from the KIMS kits that were used, unused, or expected to be used in the fresh election, whether deployed or not. My Lords, the SD cards hold the information, including the voter register, the number of voters who turned up to vote. One of the questions that is before this court, or one of the allegations that has been made, is that there was tampering with the results and the returns that have been made by the second respondent. In support of the application, my Lords, we have filed returns that were obtained by observers from the field, and which, in comparison to returns that have been filed or were publicly displayed in the public portal by the second respondent, are at variance. There are also returns that show alteration of the numbers. The only way to verify the accurate numbers of persons who were alleged to have turned up to vote or who were captured is in the KIMS kit, which is the primary instrument with the voter register.